Okay, I'm going back. I'm going back.
This is an Israeli checkpoint in the occupied West Bank, a sign of Israel's military control over the territory since 1967. More than 3 million Palestinians here face about 700 different obstacles to their freedom of movement, including checkpoints, roadblocks and gates.
There's no other way to call it but apartheid. It's not only a human rights organization. I mean, anyone who looks at the situation on the ground knows it is apartheid.
Rights organizations say Palestinians are denied basic civil rights, including that of freedom of assembly, association and expression. The Oslo Accords, signed in Washington, D.C. in 1993, was supposed to bring about Palestinian self-determination. The Accords divided the West Bank into areas A, B and C. Area C, exclusively for Israelis, constitutes about 60% of the West Bank, and that figure is growing. There are up to 750,000 Israeli settlers living in about 250 settlements in violation of international law. They openly carry weapons, often intimidating, attacking and harassing Palestinians to displace them from their lands. Children in the occupied West Bank are also targeted. Israel is the only country in the world to prosecute children in military courts. Meanwhile, UNICEF says 2023 was the worst year on record in which soldiers killed 124 children. The UN Special Rapporteur, an independent expert responsible for monitoring human rights in the occupied territories, was recently barred from entering Israel. Francesca Albanese says that's been happening for the last 16 years.
By refusing me entry, Israel is abusing of its powers as an occupying power. So as long as it remains the occupying power in the West Bank, the Gaza Strip and East Jerusalem, Israel needs to conform with the rules of the United Nations.
Recent comments by Israeli Prime Minister Benjamin Netanyahu point to a doubling down on its continued military occupation.
I will not compromise on full Israeli security control of all territory west of the Jordan River. My insistence is what has prevented over the years the establishment of a Palestinian state.
Israeli raids happen nightly now. Nearly 400 Palestinians, including more than 100 children, have been killed in the occupied West Bank since Israel's war on Gaza began in October. Mike Lappel, Al Jazeera.
Daniel Levy is president of the US Middle East Project, and he's a former Israeli negotiator. He's joining us live from London. Thank you very much indeed for being with us. With all that we've heard for the first 3 hours of the hearings in the International Court of Justice in The Hague has been the Palestinian delegation putting forward its case. How is Israel likely to respond?
Well, Rob, as you probably know, Israel has chosen not to turn up itself at these oral hearings. This is quite unprecedented, the magnitude of this hearing. People will know that 20 years ago, there was an advisory opinion offered regarding the wall that Israel has constructed illegally inside the occupied Palestinian territories. At that hearing 20 years ago, you had 15 states show up for the oral arguments, which is what is happening this week and next Monday. This time around, it's more than 50 states. This is the most that have ever been at any hearing of any case before the International Court of Justice in The Hague in history. But Israel is not going there. Now, we saw the shellacking, the quite significant crushing defeat Israel took in its case when South Africa brought Israel to the court, still being considered with regard to plausible violations of the Genocide Convention. So Israel will have others make its case for it. Of the 50 who are going to be there, less than 10 are going to be siding with Israeli kind of arguments, the US primarily amongst them. What they will be arguing, I imagine, and we've seen this in their written submissions, is the court should keep its nose out of this. It's not admissible, it's not justiciable, and crucially, that this is an issue that should be decided in negotiations. It's political, it's not legal. Why is that so important, Rob? because the question here is whether the peace process, 30 years of agreements under which Israel has just entrenched its occupation, its control, its apartheid, is the peace process something that should be untouched by international legality? International law and the peace process are two things that should never meet. This is the Israeli argument. That allows you then to have a peace process, and we're hearing now a lot of talk, especially from the US and from others, that there's going to be a new attempt to revive Oslo, to revive this peace process. And I think what they're telling us is the peace process should be an action of asymmetry, where a powerful party can bully another party with its external allies, can force it to accept things that are illegal under international law. And what this case is doing is trying to ring fence and suggest that any peace effort has to run according to international law and should not be an effort in simply recrystallizing and formalizing the existing apartheid reality.
In the cases that we heard this morning, the rulings of, the representations that were made this morning at the ICJ, Israel was being referred to as an occupying power. Now, I want to ask you about that, but I just think it's worth running through the obligations that an occupying power has under certain circumstances. In this case, it says the occupied territory must be administered for the benefit of the local population, in this case Palestinians, but Israel enforces discriminatory laws and policies, subjecting Palestinians, even children, to military rather than civilian courts. The laws state public order and safety must be ensured. However, armed settler attacks are at record levels. Israel must not displace the local population or move its own civilians into the territory. But an estimated 750,000 Israeli settlers inhabit about 300 settlements in the occupied West Bank and East Jerusalem. The occupying power is also forbidden from enforcing collective punishment on the local population, but Israel routinely destroys infrastructure, it demolishes homes, and it digs up roads. So, Daniel, I want to come back to you. Given all of that, over the years, there has been this intensification of Israeli control in particularly the occupied West Bank and also in occupied East Jerusalem. Why has there been that intensification over the years when, from the point of view of somebody looking at it from outside, it would seem that removing a lot of those obstacles, making things actually easier for Palestinians, would have provided some sort of route to some sort, if not a two-state solution, then at least some sort of calming of the situation?
Well, indeed, you've just offered us the list of things that Israel is in violation of, every single one of them. That was the argument made this morning in the court by the Palestinian representation. It's an argument you will have in various guises repeated by many of the states that will make oral presentations over the coming days, and it's there in their written submissions. The court will hear all the major structural issues: self-determination, annexation, illegal occupation, settlement, status of Jerusalem, and, crucially, discrimination. Because 22 of the states there, 24 if you include the regional groupings, have referenced apartheid, either in terms of the violations of the Convention against all forms of racial discrimination or the Apartheid Convention itself. So it's precisely the fact that international law has not been applied, that Israel has been treated with impunity and no accountability, which has allowed us to get to this horrific reality which has been described, which you described, and which we see every day on the ground for Palestinians. Now, here's where the difficulty comes in, Rob, because as we both know, this is an advisory opinion. It's not enforceable. It's not self-enforcing. So what does it mean? The idea, I think, is that not only do you ring-fence questions of international legality, but you also then dial up the squirm factor, the embarrassment factor, but also the legal complications for third parties in terms of their responsibilities and the consequences of being complicit in this violation of international law and in guaranteeing impunity for the violating party, namely Israel. Now, sometimes that may mean things go to local courts. We already saw what happened after the South Africa genocide initial provisional measures ruling in the Netherlands and the court there with regard to the provision of arms. Other things, I think, whether it's personal criminal liability, whether it's the relations they conduct with Israel, the relations that third states conduct with Israel's illegal actions in the territories, the provision of arms to enact these illegal policies. I don't want to give a Pollyannish, optimistic statement to anyone that when, in several months, the court makes its ruling, everything changes overnight. But this gives important tools, potentially new tools, for what we all know is going to be a long walk to freedom, to dismantling apartheid, but one that will pass through, by necessity, important moments of legal iteration, and around those, crucial mobilization of civil society actors, of consumers, of legal bodies, and ultimately of state actors, including the impressive submissions and arguments that I think we will hear from very important states, notably those in the global south, and notably those who have lived under apartheid and colonization in the past.
Daniel Levy, we appreciate you being with us on Al Jazeera. Thank you very much indeed.